Good evening, friends. Let's start our discussion for today. In the last class, we discussed the importance of communication of acceptance. We saw that acceptance must be communicated and that a mere decision in the mind is not enough. So, we've clearly seen with the help of examples that it is a mandatory condition that acceptance must be communicated, except in those two scenarios that we had talked about yesterday. One was general offer, and the other was specific offer, where the offerer himself tells the offeree that you do not need to communicate your acceptance to me. You just need to perform the conditions of the offer. But other than these two scenarios, the law is quite clear that acceptance has to be communicated, and that a mere decision in the mind is not enough. Means that the offeree cannot just think in his mind that yes, I accept the offer. Unless the offeree communicates it to the offerer, there is no valid acceptance. Just because you keep something in your mind does not mean that you have validly accepted the proposal or offer. We had also seen how can the acceptance be communicated. We saw three ways. One, by words, which means verbally. Then in writing. And third, by conduct. So an acceptance could be communicated in any of these three manners. Okay? Today we will take this discussion one step further. And the first part of our discussion is going to be that acceptance must be communicated to the offerer. So by now, I'm sure all of you are clear with the point that in an agreement we have two parties. One is an offerer, the other one is the offeree. So offerer is the one who makes an offer, offeree is the one to whom that offer is made. This principle says that acceptance must be communicated to the offerer. Offerer makes an offer, offeree communicates acceptance. So this is also clear that acceptance will always come from the offeree. Okay, because an offer is being made to the offeree. So only an offeree can communicate his acceptance. Now this principle says acceptance must be communicated to the offerer. So it's quite simple. Offeree has to communicate his acceptance to the offerer. So acceptance has to flow like this. Acceptance has to flow from the offeree to the offerer. This is our first principle. So that leads us to a question. What if the acceptance of the offeree does not reach the offerer? What if the offeree's acceptance does not reach the offerer. When can it happen? One scenario could be when offeree communicates his acceptance to a third party and not the offerer. Let's look at an example to understand this better. There are two parties, A and B. A offers to sell his car to B at rupees 1 lakh. B is okay with the offer. B is ready to buy the car. But B, instead of telling A, B tells C. B tells C that I accept the offer. Question is this a valid acceptance? We just saw that acceptance is valid when it is communicated to the offerer. Who is the offerer in our example? Offerer is A. Has B communicated his acceptance to A? The answer is no. B communicated his acceptance to a third party who is not the offerer. C is not the offerer. Hence, there is no valid acceptance. Okay, we'll look at one more example, which is also a very famous case law. In this case, what had happened was there were two parties, uncle and his nephew. Uncle makes an offer to the nephew. Uncle makes an offer. Uncle tells the nephew, so he tells the nephew that I want to buy your horse at rupees 100. And if I don't hear from you in the next 2 days, I will assume that you have accepted my offer. Okay? So uncle is telling his nephew that I'm interested in buying your horse. This is the price that I'm offering for your horse. And if you don't communicate, if you don't say anything for the next 2 days to me, then I will assume that you have sold your horse to me at this price that I've offered you. Now, when this letter or communication reaches the nephew does not reply. The nephew does not reply to the uncle, to the uncle's communication or to the uncle's offer. However, the nephew was also interested in selling the horse. So just a few days before this offer from the uncle reached the nephew, what the nephew had done was, nephew had arranged for an auction to sell the horse. And he had appointed an auctioneer, the person who was going to conduct the auction. Okay? And that is why when the uncle got to know about this auction, that is when the uncle wrote to the nephew about the horse, that I want to buy your horse. And nephew is also happy that, okay, why conduct an auction now? I've got a buyer and I'm okay with this price. So nephew tells the auctioneer Do not conduct an auction now. Do not conduct an auction. I have already sold this horse to my uncle. This statement from the nephew clearly implies that nephew was okay with the uncle's offer. However, there's a mistake on the part of the auctioneer. Auctioneer makes a mistake. Auctioneer makes a mistake. He goes ahead and conducts an auction. And sells the horse to a third party. Despite the fact that the nephew had given him a clear instruction not to conduct an auction, the auctioneer still went ahead, conducted an auction, and sold the horse to the highest bidder. Uncle gets to know about this. So uncle sues the nephew, saying, there was an agreement between us and you breached the agreement by not selling the horse to me. Now, the matter reached the court. If you were the judge in this matter, how would you have decided this? And apply the principle that we just discussed. The principle that we discussed was acceptance must be communicated to the offerer. This is the principle before the court. Acceptance must be communicated to the offerer. In uncle-nephew scenario, who is the offerer? Uncle. Who is the offeree? Nephew. Acceptance has to come from nephew to uncle. Question: did nephew communicate his acceptance to the uncle? Did he do that? The answer is no. The nephew never communicated his acceptance to the uncle. In fact, nephew never wrote back to uncle's offer. Nephew communicated his acceptance to a third party. Who was the auctioneer. And we know that a communication by the offeree to a third party is not a valid communication of acceptance. Acceptance always has to flow from the offeree to the offerer, which did not happen in this case. Therefore, there was no valid communication of acceptance, and therefore there was no agreement. Okay. And also look at one interesting thing here. The example that we just discussed, in this case, at least the nephew was willing to sell the horse, and nephew was okay with uncle's offer. The agreement was not concluded only because the nephew did not communicate his acceptance to the offerer. That was the only technical glitch. But other than that, he was okay with the offer. However, if you look at this offer carefully and read this line. If I don't hear from you in the next 2 days, I will assume that you have accepted my offer. Do you think this kind of an offer can lead to an agreement? Now think of a scenario where a coaching institute, you visit the website of a coaching institute and you click on one of their courses for CLAT. The moment you click that, The moment you click on that button, a new page opens. And there you see one condition. It says that if if you don't communicate clearly to the coaching institute that you don't want to take their course, they will assume that you have accepted enrollment for this course. Can the coaching institute do that, and can they bind you to this kind of offer? If you, let's say you don't write back to the coaching institute saying, no, I don't want to enroll for this course of yours, can the coaching institute later say that since you did not communicate your rejection to us, therefore it is a deemed acceptance from your side? Can they do so? The answer is no. The answer is no. That brings us to our next principle. Offerer cannot impose burden of refusal on the offeree. And the example that we discussed was that of a coaching institute and you. Coaching institute is the offerer, you are the offeree. Coaching institute says, if you do not reply within 24 hours, we will assume that you have joined our course. You do not reply within 24 hours. Can the coaching institute say that your rejection or non-communication will lead to a deemed acceptance by you? Does this constitute deemed acceptance by the offeree? The answer is a clear no. Why? Because an offerer cannot impose burden of refusal on the offeree. If an offerer makes an offer like this, there is no obligation on the offeree to communicate either the rejection or communicate at all. Basically, that you can choose not to communicate. You're not supposed to communicate anything to the offerer. You can just keep quiet. It will not lead to an agreement. Okay, we'll discuss the last part for today, which is part 3. Acceptance must be communicated by the offeree or authorized person. So the first principle that we had seen was that acceptance has to flow from the offeree to the offerer. Okay? If you remember, A is offerer. The emphasis that we put on while discussing the first principle was that B has to communicate his acceptance to the offerer. Okay, that was the first principle that we discussed today. But this third principle says that acceptance must be communicated by the offeree. Okay, now this is slightly different from what we discussed. And let's understand this with the help of an example. Let's say a person A applies for an interview at a company. A's friend B works in the same company. And B is also on the interview panel. After the interview is over, the panel likes A and decides to select A for the job. B decides to give this good news to A. However, later that day, the interview panel finds a better candidate, finds a candidate who is better than A. And the panel selects that other candidate and not A. Now keep in mind one thing, when the panel initially interviewed A, even though the panel liked A and decided to select him, the panel or the company never communicated to A that you have been selected for the job. The communication had gone from A's friend B to A. B was the only person who had communicated the selection to A. Just keep this in mind, in your mind for now, that communication was made by B and not the company or the interview panel. After A gets to know that he has not been selected, A sues the company. A's case is company had already communicated their acceptance. Hence, they cannot go back on their words now. Essentially means that the company cannot breach the agreement now. Once they communicated to A that he had been selected, the company could not breach that agreement. This is A's case. Company's response is, we never communicated our acceptance to A. Communication by B, who even though is a company's employee, is not a valid communication of acceptance. So they are saying communication by B is not valid because B was not authorized to send this communication only the HR of the company was authorized to communicate whether a candidate had been selected or rejected. Company also said that B never communicated in his official capacity. B never communicated in his official capacity as an employee of the company. B only communicated as a friend. Now, when we look at the concept of principal and agent, both in contract law and in law of torts, you will see that many a times a principal is bound by the actions of the agent. Okay, in this case, B is an agent of the company because B is an employee of the company. And therefore, the company made this argument that yes, we agree that he is our agent, B is our agent, but the fact that B communicated the acceptance to A in his personal capacity, him being a friend of A, and not in his official capacity as an employee of the company, therefore, the company cannot be bound by B's acceptance. What do you think will happen in this case? Court saw, let's make it simple for the court. On one side, we have company. Let's start with A. On one side, we have A. On the other side, we have company. A is the offerer. A applied for the interview. A made an offer that I'm making an offer to you, the company, to have me as your employee. This was the offer from A. Company is the offeree. If the company liked A, they could have communicated their acceptance to A that yes, we will be happy to have you as our employee. Question is, did the company, the principle that we just discussed a while ago was that acceptance must be communicated by the offeree or authorized person. So let's write the problem first. Did the company communicate its acceptance to A's offer? Principle is communication of an offer has to be made by the offeree or a person who is authorized to communicate the acceptance. Okay, in this case, offeree is the company. Did the company communicate its acceptance? To answer this, we will have to look at two things. One, the company's response. Company is saying that only the HR of the company can communicate to a candidate whether a candidate has been selected or rejected. Okay, that is one. Second, we know for a fact that in this matter, the communication of acceptance was made by an employee of the company who is B, but not in his official capacity, only in his personal capacity. So therefore, we can clearly say that communication by B was not a communication by the company. Now, this we know for a fact. Communication by B was not a communication by the company. Why? Because B did not make this communication in his official capacity. Number one. And also because B was not authorized to make this communication of acceptance. Therefore, there was no communication by the offeree, which is the principle that communication needs to be made by the offeree and not by a random third party. Okay? In this case, since there was no communication by the offeree, which is the company, therefore, there is no valid communication of acceptance and hence no valid agreement. Okay? So let's summarize our discussion. First, we saw acceptance must be communicated to the offerer. An offeree needs to communicate his acceptance to the offerer. So here the emphasis is on to whom should the communication of acceptance be made. Please focus on this. The emphasis is on this portion. To whom should the communication of acceptance be made? In the second principle, we saw that acceptance must be communicated by the offeree or an authorized person of the offeree. Here the emphasis is on by whom should the acceptance be communicated. Now that is the difference between principle 1 and principle 2. The focus of principle 1 is to whom should the communication of acceptance be made, to whom, and the focus of principle 2 is by whom should the acceptance be communicated, who should be the one communicating it. Here the answer is to whom should the communication of acceptance be made? Only to the offerer, not to a third party, unless the offerer himself tells the offeree that you can communicate your acceptance to this person. And the answer to the second one is by whom should the acceptance be communicated? The answer is offeree or an authorized person of the offeree. Okay? And the last thing that we talked about was, before we discuss the last point or summarize the last point, I would like you to spend 30 seconds on these 2 points so that it becomes crystal clear to you. Okay? Let's note down the last point. offerer cannot impose burden of refusal, which simply means that an offer, like if you don't communicate your rejection within the next 24 hours, we'll assume that you have accepted our proposal. That kind of an offer cannot lead to an agreement, even if the offeree does not communicate, or does not communicate at all, or does not communicate the rejection. There is no obligation on the offeree to communicate with the offerer if that kind of an offer is made. Okay, so this was the focus of today's class. While we discussed about, while we started our discussion about communication of acceptance yesterday, and I told you that acceptance must be communicated. That is a mandatory thing when it comes to agreements and contracts. Today, my goal was to help you understand it a bit further by explaining two things. Number one, to whom should the acceptance be communicated? So, yesterday we saw that acceptance needs to be communicated. Today's goal was to understand to whom should the acceptance be communicated, and then by whom should the communication of acceptance be, sorry, by whom should the acceptance be communicated. Now, that was the focus of today's class. I would like you to revise yesterday's lecture once more and then understand today's class so that you have complete clarity on communication of acceptance. Tomorrow we are going to discuss the mode of acceptance. Okay? All right, revise and study well. Thank you so much. Good night.